Hello, my name is Patrick Foley, and my topic for our Information Systems course is focused on the question of, is privacy a right? Before I get into my presentation, I would like to set forth an agenda. The first slide we focused on defining privacy and the laws associated with that. The second slide will be focused on data privacy. The third slide will be focused on workplace privacy in terms of employees' expectations in regards to their data and the way they can interact within the workplace. And the final slide will have my discussion questions. Privacy is defined as the state or condition of being free from being observed or disturbed by other people. Privacy is never explicitly mentioned in the Constitution of the United States, nor is it listed under the Declaration of Independence list of inalienable rights. In fact, the closest privacy comes to being mentioned in the Constitution is in the Fourth Amendment. The Fourth Amendment states, "The rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and nor warrants shall issue but upon probable cause." Yet, nowhere in the Constitution or the Declaration of Independence is privacy ever explicitly stated by word or in definition. Privacy is understood in the context of constitutional law as liberty or freedom to act in personal matters. As a result of this, there have been a multitude of laws and federal guidelines that have been put into place in regards to individual privacy. The two acts that have had the most effect on an individual's privacy is the Privacy Act of 1974 and the American with Disabilities Act of 1990. The Privacy Act of 1974 established a code of fair information practices that governs the collection, maintenance, use, and dissemination of information about individuals that is maintained in the systems of records by federal agencies. What this act focused on was that the information that was collected about people was only to be utilized in terms of national security risk or if there was an immediate illegal threat. It basically focused on how people would not have to be worried about their private lives coming into contact with any federal agencies or public entities unless it was required to do so. The American with Disabilities Act of 1990 prohibited employment discrimination against qualified individuals with disabilities. This act ensured that potential employees were not forced to disclose any disabilities that may have hindered their ability to be interviewed or hired for a specific position. The act focused on a number of aspects, including privacy expectations and the reasonable types of modifications that employers were required to make. In terms of protecting one's data, there have also been a multitude of laws and acts that have been put into place that are focused on providing privacy about one's personal information. There are three acts that are specifically focused on the privacy of one's personal information. They are the Children's Online Privacy Protection Act of 1998, the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act of 2001, which is also known as the U.S. Patriot Act, and finally, the E-Government Act of 2002. The Children's Online Privacy Protection Act of 1998 imposed certain requirements on operators of websites or online services that directed their websites to children, specifically under the age of 13, and the knowledge that the operators were able to ascertain about these children's personal information. The act was basically put into place to ensure that children had a safe place to function on the internet and would not have their personal information stolen or disseminated amongst illegal entities. The U.S. Patriot Act was a response to the 9/11 terrorist attacks. It's probably the most famous act that is focused on personal privacy, and especially in terms of electronic data. The act was put into place to deter and punish terrorist acts in the United States and around the world, and to enhance law enforcement investigative tools in the name of protecting the U.S. and their entities. The E-Government Act of 2002 was an act to enhance the management and promotion of electronic government services and processes by establishing a federal chief information officer within the Office of Management and Budget, and by establishing a broad framework of measures that require using internet-based information technology to enhance citizens' access to government information and services and for other purposes. The Act focused on enhancing access to government information and services in a manner consistent with laws regarding protection of personal privacy, national security, records retention, access for persons with disabilities, and other relevant laws. This was basically put into place so that citizens could hold the government responsible and to create more transparency in terms of the personal information the government had access to. In terms of personal information in regards to social media is not covered under any privacy laws or regulations. The main consensus states that once individuals share their social information through a social media public forum such as Facebook or Twitter, all privacy ceases to exist. Privacy around social media only comes under scrutiny when information is leaked. Having one's personal identity stolen usually comes as a result of their social media account being hacked or information from that social media being shared throughout the public domain. Finally, we lead into workplace privacy. Technically, employees do not have a reasonable expectation of privacy once they enter into the workplace. However, workplace privacy for employees is dictated by both the federal government and individual state labor departments. However, each state may have different variations in terms of employee privacy or what they consider to be protected under privacy laws. The fact of the matter is that private sector businesses have less of a burden to prove that an employee's rights to privacy were violated. However, as previously stated, there have been a multitude of laws that have been put into place to protect employees within the workplace. One of the two of the most prominent laws in terms of personal data and employee privacy are the Electronic Communications Privacy Act of 1986 and the Employee Polygraph Protection Act. The Electronic Communications Privacy Act of 1986, otherwise known as the ECPA, prohibits employers from intercepting any wire, oral, or electronic communication without employees' consent. However, if this communication is conducted on an employer's company-owned laptop, computer, phones, or cell phones, employers are allowed to listen or intercept those communications. This is because since the employee does not own that piece of equipment, any correspondence that occurs is technically owned and regulated by that employer. The Electronic Polygraph Protection Act otherwise known as the EPPA, prohibits most private employers from using lie detector tests either for pre-employment screening or during the course of employment. The EPPA Act states that employers generally may not require or request any employee or job applicant to take a lie detector test or discharge, discipline, or discriminate against an employee or job applicant for refusing to take a test or for exercising other acts that are protected under the EPPA. The Act also states that employers may not use or inquire about the results of a lie detector test or discharge or discriminate against an employee or job applicant on the basis of the result of a test, or for filing a complaint or participating in a proceeding action under the Act. The reason that this Act was put into place was to protect employees from self-incriminating themselves or feeling the pressure to lie under oath. Employees have two advocates for them in terms of fighting for privacy in the workplace. They are the ACLU and EPIC. The ACLU, otherwise known as the American Civil Liberties Union, is a strong proponent for employee privacy. As the ACLU states on their website, they continue to fight for employee privacy by challenging how those rights are violated by employers, whether that is through workplace surveillance, unwarranted drug testing, or lifestyle discriminations. The ACLU feels that employers only have a legitimate interest in monitoring work to ensure that employees are efficient and productive. EPIC is a public interest research center in Washington, D.C. It was established in 1994 to focus the public on emerging privacy and civil liberties issues and to protect privacy, freedom of expression, and democratic values in the information age. They pursue a wide range of program activities including policy research, public education, conferences, litigation, and advocacy. They routinely file amicus briefs in federal courts to ensure that they are defending employee privacy and consumer privacy to ensure that no laws or privacy is violated. Here are my discussion questions. Do you think companies care about employees' privacy? What type of employee data do you think companies should even have access to? Is there even a reasonable expectation of privacy in this modern age? And finally, since this is a managerial type course, as a future manager, how will you respect your employees' privacy? What is your expectation? Thank you again for listening, and I appreciate your participation.